Yeah, there's no legal rule, statute, or constitutional standard that would limit or prohibit this type of proceeding that's being put forth with respect to the confirmation hearings for Amy Coney Barrett. What the Democrats' main argument is based on precedent in terms of what the Republicans said and did with respect to the nomination and confirmation hearings of Judge Merrick Garland. And the arguments that the Republicans put forth against that confirmation, the Democrats said should be precedent for this particular confirmation. But the Republicans have reversed course. They've given reasons, whether they're valid or not, is questionable. But there's no rule or statute or Senate rule, statute, or constitutional limitation on what the Republicans are doing with respect to these confirmation hearings.
Dr. Ross, can I just weigh in and ask you about this conservative-leaning bench, then a court with a 6-3 conservative majority that transpires? What are the ramifications? Because just because someone is conservative doesn't necessarily mean they will rule a certain way. We've been talking, for instance, around SCOTUS and just the interpretation of the law, whether it's a working document, a real-life document, or treated differently. So how do we interpret the ramifications of the way the bench would be set up?
Yeah, the ramifications, we do have a working, evolving document. It's open-ended. It's quite vague and ambiguous in many of its terms when we're talking about the Constitution. And it gives the court and judges quite a bit of discretion in terms of how that document is to be interpreted. In the United States, there's quite deep divisions, often along ideological lines, about how the document should be interpreted to protect or to treat things like the right to privacy, which was part of the discussion today, the right to what equal protection means in terms of protecting against discrimination on the basis of a variety of characteristics, and what separation of powers means, how much executive power, how much power should the executive have, how many limitations can Congress place on those powers, and what the relationship between the states and the federal government are. These are sort of deep and abiding divisions that exist within our polity and in legal circles on these particular issues. And there is often a conservative position on these issues and a liberal position on these issues. And given that the court will now be 6-3 and a firmly conservative court, it means the conservative vision on these issues will likely prevail. Now, does this mean whole widespread reversals of past cases? Probably not. But I do think that you'll see a subtle but distinct shift in a conservative direction with respect to these fundamental issues under our Constitution.
Dr. Ross, I've got